Her Ladyship Justice Professor Henrietta Joy Abna Nyako Mensa Bonsu. Thank you very much. The name alone should tell you the kind of person we have here today. The Dean of the Faculty of Law, heads of department present, members of the academic community present, our students, ladies and gentlemen. We are welcome to today's public lecture with a topic, In the Beginning is the Word, a ringside view of the significance of procedural rules and pleadings in the practice of law. Now, follow this topic or the flyers and adverts of this program on social media. And even before anybody or those on social media could hear or can hear what this is about, I've seen some debates. Some have been asking if there's any correlation between this lecture and the origin of the phrase, in the beginning was the word. Some are asking if perhaps Professor or Her Ladyship Justice Professor Mensa Bonsu has taken a new job of being a minister of the gospel, and she wants to link it to her practice of the law. Well, I do not know much about it, but that's why we're here. A part of that curiosity is what has brought us here, and that part of the fact that I want to listen to the wisdom from Her Ladyship Justice Professor Mensa Bonsu. So we can get started and move quickly to hear the lecture. We'll take our opening prayer, and our brother, Mr. Gianza, will lead us in the opening prayer.
Shall we bow in prayer? Dear God, our Heavenly Father, we are grateful unto you for the gift of life and for the fact that you have gathered here today to listen to this public lecture from your daughter. We are praying, dear God, that you grant wisdom, you grant discernment, and you help us all to bring this session to a successful end. We pray that impartation will be made in this session, and may you protect us all and give us a good session so that in the end, we'll have every reason to give you praise and thanks. In the mighty name of Jesus Christ have I prayed with thanksgiving. Amen.
Amen. Thank you very much, Mr. Gianza. Well, I'm also a lover of custom. I believe in traditions a lot. And typically, we know that if you go to the house of anybody, usually the people in the house will ask the guest that, or if you're part of the account committee, that a kwanswe. But we have an eminent person with us, and I don't think we may have to go with that tradition. So we invite our dean, who is our father here, to tell us, rather, the purpose of this gathering.
Your Ladyship, Professor Henrietta Mensa Bonsu, Mr. Mensa Bonsu, the husband, distinguished colleagues, students, ladies and gentlemen. Professor Mensa Bonsu was invited to speak today at the UPSA Law School, an invitation I extended very early in her life on the bench, and an invitation she very quickly initially declined. True to the person I have known for some time, for good reasons which I would not have to share. But she assured me that in the nick of time, she was going to come back to me and let me know when it was appropriate to speak. True to her promise, she called me out of the blues that it was time. She would be happy to share a word or two with the UPSA Law School and the Ghanaian public on matters of importance that affect the legal profession and the academy. When Professor Mensa Bonsu mentioned to me the topic she would like to speak on, I need to confess, I was a bit surprised. And the reason I was surprised is because knowing who she was as a student, me being a student, she was not given to form, but rather more devoted to substance, the person I have known. but the topic clearly is one that speaks to procedures. And probably my own surprise also stemmed from the fact that I have labored and constantly watched on, usually in vain, seeing lawyers stultify legal rights on grounds of procedural tactics. And therefore, that frustration is something I have always reflected on and wondered how we can overcome that. So hearing Prof speaking on the significance of procedural rules to the legal practice, I thought there must be something intriguing she would like to share with us, especially given her life on the court at the moment. Today, UPSA Law School is delighted to be the first, I hope I'm right, the first place, the first venue, and the first platform on which Prof is going to share her perspectives on issues affecting the law and legal practice. And the topic speaks for itself, particularly the word ringside. Someone who is very close indeed to the action and can speak with the bifurcated lens of an academic. When I used to be her student, I stand here because I passed her subject. Without ease, I can assure you. So the bifurcated lens of an academic, but also the deep insights of a judge at the highest level of our judicial hierarchy. It is on the basis of that, and together with her support, that I would like us to invite Professor Mensa Bonsu. Not to invite, but to welcome Professor Mensa Bonsu. Please clap. To welcome Professor Mensa Bonsu to the UPSA Law School, and as someone who was in Legon, the University of Ghana, for so many years, I'm not sure what she would think about this, but the UPSA Law School, which is the best law school in Ghana today. To welcome Prof to our midst. And at this stage, I'm going to ask the MC to officially welcome Prof to the days. But before that, let me also acknowledge one or two people I've seen here. I've seen one of my former colleagues at GIMPA, Mr. Akapame, who I'm sure may be advertising an intention to join us. But that's quiet, not to be said anywhere. But yes, we're very happy you're here. Mr. Akapame, welcome to the UPSA Law School. So I'm sure in due course we'll recognize and welcome all those other people who are joining us. So thank you very much and welcome again, Prof.
Thank you very much, Dean. And I must be quick to associate myself with the Dean and also say that I was also once a student of Professor Mensa Bonsu, and I also passed the exam, and that's why I'm here. We just want to take an introduction of Professor. We've probably heard of her as a Justice of the Supreme Court, but who exactly is she? What has she done before? We invite Ms. Kwe to give an introduction of Professor Mensa Bonsu.
Good afternoon, ladies and gentlemen, all protocols observed. I have the singular honor to introduce Justice Professor Henrietta Joy Abna Nyako Mensa Bonsu. She is a Justice of the Supreme Court of Ghana. Before her appointment to the bench, she was a professor of law at the University of Ghana School of Law and served as the director of the Legon Center for International Affairs and Diplomacy. She is the immediate past president of the Ghana Academy of Arts and Sciences. She has had a distinguished academic career spanning more than 3 decades at the University of Ghana since joining the University of Ghana as a lecturer in 1985. She rose through the ranks to attain the rank of a full professor in 2002. She has undertaken a number of high-level national and international assignments. Her national assignments include membership of the National Reconciliation Commission and the Ayawaso West Wuogon Commission of Inquiry into electoral violence. Among the high-profile international assignments she has undertaken are the OAU's Committee of Eminent Jurists on the Lockerbie case 2001-2002, in the AU's Committee of Eminent Jurists on the Hesseini Habre case, 2006. In 2007 to 2011, she was a Deputy Special Representative of the United Nations Secretary General for the Rule of Law, DSRSGROL, in the United Nations Mission in Liberia, UNMIL, with the rank of an Assistant Secretary General. For 4 years, she had the privilege of leading the United Nations family effort to reconstruct the rule of law sector of post-conflict Liberia. Since 2012, she has served as a civilian mentor to the ECOWAS Senior Mission Leadership Courses, United Nations Senior Mission Leadership Courses, and the UN Police Commanders Courses, all of which she prepared principal leaders for peacekeeping missions. In 2015, she was appointed to the UN Secretary General's High-Level Independent Panel on Peace Operations, HIPPO. And in 2017, she was Ghana's candidate for the seat on the ICC. Currently, she serves on the advisory board of the Division of Peace of the United Nations Institute for Training and Research, UNITAR, and is a member of Board of Trustees of the Methodist Church of Ghana. Professor Mensa Bonsu has researched and published extensively on criminal law and criminal justice, particularly juvenile justice, family law, children's rights, and more recently on international affairs. She has been a visiting lecturer at a number of reputable universities in Europe and North America, and in 2014, diplomat in residence at the School of Public International Affairs of North Carolina State University. Justice Professor Mensa Bonsu has earned a number of academic awards and non-academic awards and citation. The most recent of these non-academic awards are the Ghana Women of Excellence Award 2019, West Africa Peace Fellow, WANEP 2019, and the NACS Prestige Awards 2019 for Peace, Advocacy, Academic Excellence, and Institutional Advancement. Justice Professor Mensa Bonsu is married with children and grandchildren. Can we all please be upstanding and with a round of applause, welcome Her Ladyship, Justice Professor Mensa Bonsu.
Thank you. These days, taking off the mask makes me nervous. So, thank you very much. The Dean of UPSA Law, distinguished faculty of UPSA Law, my honored spouse, Henrietta Mensa Bonsu. Oh yeah, he's been my spouse for 40 years. Professor Henrietta, my master. He was a master of Akwafu Hall, and he appointed me senior tutor of Akwafu Hall. We worked together well, and we are still friends. And my daughter, Mamia, who has joined the profession. Not law, teaching law. Yes, she is at Legon, moved from Lancaster. Let me begin by thanking Dean Abuchi. It's such a pleasure to see your former student, a dean and professor, while you are young enough to walk around. And so my agreeing to do this lecture is really to honor him and to support the efforts that he's making. My experience of law schools abroad is that the only thing they have over us is the number of prominent people they bring to come and speak to the students. Otherwise, we don't fall short in any way. So it's our duty to help so that you get the kind of education that makes you comfortable wherever you are, that you are among the best. I've prepared a lecture. I did not want to take the risk of speaking off the cuff because a professor who has missed speaking to a class for a whole year is not a safe subject to leave with a microphone and an audience. And so I'm going to read the lecture that I've prepared. May I go on, Mr. Dean? Yes, please. I have heard comments also about my choice of topic, and some are beginning to wonder if being close to Trinity Theological Seminary has anything to do with. Let me just say that it is always my way of capturing the essence of something very serious in the law by using means that excite you to want to find out. In the beginning is the word. When I started, it was in the beginning was the word. And I said, I don't want religious cranks on my back. So I changed the tense of the verb. You have to produce the Bible that says in the beginning is the word. This biblical sounding phrase is not indicative of a sermon I intend to deliver to you in honor of my first anniversary as a justice of the Supreme Court. That certainly would have been appropriate in a different forum, particularly as, thanks to COVID-19, the celebration of that epochal event was considerably muted. I have chosen to frame my topic in this manner because of the significance of proper beginnings in any endeavor, litigation before the courts being no exception. As all litigation begins with pleadings, and all courts derive their authority from the language of the Constitution, statute, or subsidiary legislation, it is my way of drawing attention to the language of pleadings and the operational bounds of the law as I have observed and practiced in one solid but eventful year on the bench. Therefore, the essence of this mode to address you today is to highlight my experience of the value of language use, or the word, as manifested in the strictures of statute and the critical importance of procedural rules in shaping substantive law. My sense of vindication in insisting that my students pay attention to appropriate use of language has also been reinforced, as from a ringside seat, I have observed the effect of improper adherence to the sense, essence, and integrity of the word. I have also been privileged to observe how a failure to comply with the word within bounds set by statute and the practical manifestations thereof could bring any litigation, however well-intentioned, crashing down from lofty heights. Thus, this reflection is important for any student of law, law student, or legal practitioner, as feedback from the other side of the fence. This past year, the process of transitioning from academia to the courtroom has not only entailed physical relocation, but a mental one as well. If I may add, I have swapped 5 minutes driving time to my office from my home to more than an hour on the crazy roads. I have come to appreciate that one must negotiate the procedure jungle before reaching substantive law, and that justice begins with creating a level playing ground for both sides to a dispute by adhering to the rules prescribed in advance. This has been quite an epiphany and necessitated an adjustment and a turnaround in my personal mindset. Dean Abochi did not joke when he talked of me and substance, but I'm born again. I have gradually come to accept that if indeed there's a hierarchy of rules in the quest to do justice, then perhaps in the business of setting standards for justice as between parties, procedural rules come ahead of substantive law. If one is to uphold the rule of law and ensure fairness to parties in dispute, then one must begin with a respect for laid down principles of procedure as set down by the word, for they set the terrain and define the mode of doing battle, especially in adversarial proceedings. The system of common law has underlying principles that constantly reinforce the fact that form is as important as substance when it comes to the enterprise of doing justice. For instance, the common law favors orderly development of the law against vigilante justice. No pun intended. Level playing field as between disputing parties instead of favoritism. Transparency in the mode of access to justice instead of opacity. And the abhorrence of ambushes and surprises. It is for this reason that any conduct that appears to shift goalposts midstream, etc., is discouraged and even penalized as springing a surprise on an opponent. These are values encapsulated in the rules of procedure and which, when accorded respect, raise the arena of justice from the skullduggery and backstabs that disputing parties are apt to resort to achieve victory. The saying, all is fair in love and war, reflects the lack of morality of means that disputing parties are apt to adopt unless restrained by rules that are impartially applied by neutral arbiters in dispute resolution. With the possible exception of American and Canadian law schools where procedure is part of the JD curriculum, most other places in the Commonwealth still maintain the division between substantive law in academic law studies and procedural law in professional law courses. This has the effect of making law students believe that substantive law principles are superior to procedural law principles. Nothing, as I have found, could be farther from the truth. Indeed, it is not unusual in intellectual debates within law schools for technical rules to be sometimes described in pejorative terms as technicalities, and you do it with a lowering of the voice, to show that it is low, which only obscure the law, and for cases won on technicalities to be regarded as somewhat inferior to those won on substantive principles. With this mindset within the hallowed walls of academia, it is a hard road for one to come to an appreciation that, in fact, procedural rules sit on top of substantive rules. In reality, the procedural rules determine their shape, reach, and applicability of substantive principles, thereby dictating if and when justice could be attained in the courts. This process of mental reawakening and repositioning of procedural law is unsurprisingly a path that has been trodden before my time. It must regain its pride of place because it is within the bounds of the existing law and procedure that any action may be lawfully taken in court, even when it seems to frustrate the ideal of justice. And this lecture is therefore an attempt to take other students of law on a journey to share some of my experiences from a ringside seat. It begins by setting the scene with the philosophy of the concept of rule of law and the role that procedural rules play in achieving its ideals. It then zooms in to examine the importance of rules of procedure in the enterprise of justice delivery, from the standpoint of one whose respect for procedural rules has been rekindled from a ringside seat. To give substance to the discussion, the paper focuses on a few selected aspects of law that constrain the courts and illustrate the import of procedural rules on the practice of law and the delivery of justice. The selection is made in order that issues relating to pleadings, jurisdiction of the courts, appeals, etc., could be highlighted as necessary equipment that must have pride of place in the toolbox of students of law. Note that the reference is not to law students, but students of law, because the enterprise of legal practice demands constant study if one is to remain abreast of law. Such focus on specific examples from decided cases, I believe, would of necessity foster an appreciation of the strictures of procedural rules and encourage compliance with the rules. It would also show the need for diligence when drafting legal processes and demonstrate competence in language as a tool of a lawyer's craft, all to the end that justice would be meaningful to anyone who seeks it either as lawyer or client in the courts. So I look at rules and rule of law. The rule of law is a concept that has dominated the terrain of constitutional democracies for as long as anyone can remember. The concept has both formal and substantive aspects. It connotes orderly conduct in the making and enforcement of law according to previously established principles. Its inherent tenets, such as equality before the law, give the law its aspect of fairness and decency. Beginning with the setting of the philosophical tone, underlying respect for procedural rules as a fully fledged aspect of the rule of law, this lecture demonstrates that the ideal of rule of law is unattainable without rules of procedure. It seeks to make the point that the principles of rule of law which we bandy about do not only reflect the substantive law, but more the procedural forms by which justice may be attained by the citizen. Indeed, the realization of the purposes of the law in the attainment of justice are inextricably tied to the respect for the rules enacted to guide the practice of law. An American scholar, Robert Summers, has argued that process also has values which count in ensuring fairness and justice, even if, quote and unquote, vigilante justice or, quote and unquote, spontaneous justice might also yield a good result on occasion. In Professor Lon Fuller's famous exposition on the morality of law, he uses the allegory of a monarch he calls Rex the First, who set out to reform the legal system in his territory, but who failed miserably in the process. Fuller used this allegory to demonstrate the practical implications of law and justice when there is no certainty, coherence, or predictability in the development and application of law. This, then, is the function that rules of procedure perform in the attainment of the ideal of the rule of law. I prepared this paper for publication, so I'm going to skip the long quotations so that I don't hear any sounds that suggest that you have mistaken the auditorium for your bedroom. Not to be outdone by foreign scholars, Badegbe JSC of the Supreme Court of Ghana has urged stricter enforcement of the rules of procedure in order for the law to achieve its purposes. In Opoku number 3 against Access Company Limited number 3, he opined that the Supreme Court, by enforcing procedural rules to the letter, provided the only means by which meaning could be given to due process and the rule of law. He urged the point on his colleagues thus: "My lords, permit me to say that the time has come for the Supreme Court, in the exercise of the powers conferred on it under the practice and procedural rules of court, to ensure strict compliance with the conditions contained in the enabling rules in order to give real meaning and substance to the purpose for which the rules were enacted, and more importantly, to give effect to the expectations of society that in the exercise of the Supreme Court jurisdiction, we shall hold parties who appear before us to the clear words by which the rules are expressed. This, to my thinking, is the only way to give effect to the requirements of due process and the rule of law," unquote. Thus, a reference to due process within the framework of rule of law as essential to the pursuit of justice is an admission that the mode by which rights and claims may be vindicated is a real channel through which justice may be purveyed. So I look at procedural rules in litigation. Process is cardinal to orderliness, and so procedural rules are enacted to guide both the form and substance of any litigation. For positivists, I hope there are students of jurisprudence here. For positivists, this is the means by which the legislature retains control of its lawmaking powers. When they state that judges do not make law, even though in reality their application of law itself is an aspect of producing new law, they mean that it is the legislature that controls what law is and how it may be made. Thus, from the beginning till the end, the delivery of substantive justice is controlled by legislative prescription and intent. For neo-naturalists of the fuller tradition, it is the means by which, quote and unquote, the adequate notice by rules made in advance and publicized infuse the moral ideal of fairness and justice into the process of dispute resolution. As Thomas Aquinas always maintained, there is a nexus between means and ends, and so one cannot use unjust means to attain a just end. Without procedural rules, the effort to deliver justice would be stymied by manifest lawlessness and lack of respect for the values of predictability, decency, and certainty, which are the basic values of the common law system. So I look at pleadings. Communicating a grievance is the first step in any process of dispute resolution, litigation not excepted. Therefore, clear communication becomes a principal means by which the cause and source of a grievance, as well as the anticipated result of intervention, would yield for the parties. I have observed elsewhere in a previous article the importance of communication to human beings, and hear me on this one. Quote, "Communication lies at the very heart of every human activity that involves more than one person, for it offers the means by which the persons involved may transmit ideas from one mind to the other. Indeed, it is recounted in the Holy Bible that the first joint project among human beings to achieve fame and implicitly challenge God by building a tower high enough to reach the heavens failed simply because their means of communication was undermined by God. God must have a sense of humor. By making them speak in many different languages. When unable to communicate because of the confusion of languages, the resulting confusion destroyed the unity of purpose. The project failed, and the people were scattered all over the world. This biblical story illustrates most effectively the power of communication in maintaining unity of purpose for the achievement of a common goal. The means by which lawyers initiate litigation is by communicating the plaint of the person with a grievance or complaint to the one who they perceive as the source or cause of the complaint. The law has defined what a claim may consist of and how it may be framed. Thus, having recognized a cause of action, drafting pleadings that comply with laid down rules, communicating the grievance to the opposing party in prescribed form, and advocating one's position according to laid down principles are the lifeline of every litigation and fundamental to vindication of any grievance. Thus, with pleadings being the means by which parties communicate, it is absolutely critical that they should contain all the law requires to determine the viability of their claim, as well as the resolution of that claim. Where the language used is poorly crafted or in bad grammar, is imprecise or obfuscatory, making demands that do not exist in law, or seeking reliefs that a court is not empowered to grant, the action may be defeated by such poor communication. For the law student or student of law, for the two are not the same thing, this means hours of study and reading of cases to understand. Note, I said reading of cases, not head notes, like many of you. To understand and appreciate the basis of a legal principle, especially when one rejects that principle and wishes to see it expunged from the system. Law students must also appreciate that while imprecise and even approximate answers may earn marks in academic law, nothing like that is possible with procedural law. Therefore, those who tout their previous high academic credentials as a basis for questioning examination results at the professional end of legal training would be well advised to take heed. For procedural law, the answer either is or is not. Where alternatives are available, the rules clearly say so. There is no room for perhaps, probably kind of answer. And luck in making correct guesses may carry one thus far and no further. Therefore, one must form habits of study and research that ensure attention to detail in the course of one's legal education. This gives further vindication that the constant haranguing of law students by their law teachers to read for themselves, read and read again, has justification. There's a quote from an American that I will skip. A pleading is basically how one appears before the courts. According to Black's Law Dictionary, pleading is a formal document in which a party to a legal proceeding, especially in a civil suit, sets forth or responds to allegations, claims, denials, or defenses. My brother, Marful Sao, JSC, in his invaluable book, yes, when you join the bench, you now acquire siblings instead of friends. In his invaluable book, A Practical Guide to Civil Procedure in Ghana, defines pleadings as, quote, the written statements of facts exchanged alternatively by parties within prescribed time frame aimed at ascertaining the issues that the parties would want the court to determine. In Order 82, Rule 3 of the High Court Civil Procedure Rules, CI 47, pleading means formal allegations by the parties to a lawsuit of their respective claims and defenses with the intended purpose of providing notice of what is to be expected at the trial. This means that the pleading communicates to the court as well as parties on the other side what information the parties expect to bring before the court for trial. Where the pleading discloses no cause of action, the litigation will be short-lived. And when it contains no triable issues, it would suffer the same fate. Witness statements. The vital role of witness statements is yet to be appreciated by many lawyers in drafting proceedings. The witness statement provided for under Order 38 Rule 3B1 of CR 47 as amended is now treated as the evidence in chief, and so must contain as much information as an oral testimony would have contained to be of effective assistance to the case of the person who makes it. Thus, care needs to be observed by counsel in the preparation of witness statements, as there will be no other opportunity except cross-examination for that evidence to be led. If you expect that your opponent will question your witness and bring out information you need for your case, you have another think coming. So leaving your opponent to cross-examine your client is taking an unjustified risk with the case of one's client. Should opposing counsel decide not to cross-examine because such cross-examination of the witness would not serve that party's purpose, how would the evidence deemed vital get on the record? It is as good a strategy as relying on opposing counsel for the conduct of one's case in the belief that whatever proof one's case needs will be provided by opposing counsel. The practice of law requires honor and decency, not altruism. It would be as well to pay attention to some helpful guidelines proffered by my brother Marfosal in his book, Keeping Abreast of Changes in the Law. Again, lawyers must keep abreast of amendments, particularly of procedural rules or rule the day. More than 5 years after the Rule 62 of Supreme Court rules were amended in CI 24 in 1999, the Supreme Court had cause to observe in Republic against High Court, Kumasi, ex parte Mobile Oil Ghana Limited, Hagen interested party, that lawyers did not seem to appreciate that the amendment of Rule 62 was not merely cosmetic, but affected the time limit within which applications for the writ of certiorari could be made. At pages 320 to 321 of the report, Dr. Seth Chum, JSC, opined that, quote, perhaps the 3 months in the old Rule 62 should not have been changed to 90 days. It creates the erroneous impression that that was what the change was about. Far from it, the change was fundamental. There is a world of difference between the date of the decision and the date when the grounds for the application first arose. I should have provided the text of Rule 62, but because we don't have time, I'm just commenting on the fact that if a law is changed and more than 5 years afterwards, counsel are operating as if the law is still the same, they will have problems. So I skip that discussion. Therefore, whenever any law is amended, care must be taken to study its import, because were the amendment not necessary, Parliament would not have made it, for Parliament does not act in vain. This is legal fiction. Don't ask me questions about it. Language of pleadings. 1, verbose, vague, or argumentative pleadings. Pleadings, particularly grounds of appeal, should not be verbose or argumentative. Both CI 16, that is the Supreme Court rules, and CI 19, the Court of Appeal rules, deal with this problem of verbose or argumentative grounds of appeal. Failure to observe the rules can have dire consequences for the appellant, as such grounds are liable to be struck out. In West Laurel Limited and others against Agricultural Development Bank, again, Dr. Chum observed, it cannot be overemphasized that counsel who elect to practice in the Court of Appeal and the Supreme Court must be thoroughly conversant with the rules of the courts. Complaining that ground 2 in that appeal was both argumentative and full of narratives, he proceeded to strike it down because it sinned against Rule 6.5 of CI 16. Such a comment would always emanate from the Supreme Court's displeasure at counsel's apparent lack of familiarity with the rules governing the process involved in the particular case. In an even more dramatic situation in International Rum Limited No. 1 against Vodafone Company, Ghana Limited, and Fidelity Bank, the Supreme Court, per Akamba JSC, had something to say about these argumentative and so on rules. Again, I skip the reading for when the paper is published, then you can read them. Fortunately for the appellants in that case, the grounds of appeal also contained what is called the omnibus ground of appeal. The judgment is against the weight of the evidence. And so the court was willing to substitute that for the worthy grounds pleaded by the appellant, in order, the court said, not to yield overly to legal technicalities to defeat the cries of an otherwise sincere litigant. So the court went to the rescue of the litigant because counsel had brought too much bofo. Deprecating the practice of filing many grounds of appeal, some are also filing so many grounds. So Fayakufu JSC, as she then was, criticized the drafting of the pleadings in Smith and others against Blankson. Thus, quote, by a notice of appeal, which is remarkable only in its incredible prolixity, the plaintiffs launched an appeal to this court against the decision of the Court of Appeal on no less than 14 grounds. The most cursory reading of the notice of appeal would show that, in fact, there are only 3 grounds of any impact to the resolution of this matter. Further, she also observed, firstly, this court deplores the prolixity with which counsel set out the claims, issues, and grounds of appeal. Many of these amounted to legal submissions and pleadings. It is not by lengthy words and paragraphs that a bad case can be transmuted into a good one. The only end served by such protracted pleadings is to waste the court's time and at times confuse the issues. She then advised counsel in a go and sin no more mood to desist, quote, from such unnecessarily rambling and wordy pleadings and submissions in the future, since the court intends to exercise its power of striking out such pleadings and submissions with more liberality henceforth. The same complaint was made by the Supreme Court in Gregory and Tanner, the Sixth and Hansen. The court, speaking through Doche JSC, held inter alia that the mode of pleading as many as 18 grounds, many of which could have been subsumed under one head, did not comply with the rules. I must say that I have seen 19 grounds, with a promise or a threat to add more when they got the record. Lest you should think it is the Supreme Court which is finicky about compliance with Rule 6 of CI 16, the Court of Appeal is of the same mind in respect of like provisions in CI 19, in obeying against Shama Traditional Council and 2 others. This is a 2020 case. The Court of Appeal, speaking through the Akwasari, Justice of Appeal, made the observation. His own language was interesting, so I'll read it. Even at first blush, the plaintiff's notice of appeal appears to sin egregiously against fundamental and perhaps elementary statutory imperatives required for a valid formulation of grounds of appeal in compliance with the provisions of Rules 8, 4, 5, and 6. Their rules are 8, ours are 6. In this instant case, it is clear that by failing to formulate even one allegation, either of fact or law, against the ruling appealed against, the plaintiff's notice of appeal suffers from the obvious grievous defect of being at once vague and narrative, disclosing no reasonable ground of appeal, and to that extent constituting a gross abuse of legal process, unquote. What do you think happened to this case? You think he won? Oh, you think he won? I thought you thought the judge was so impressed by the verbose pleadings that he won. He followed up with criticism of counsel for the plaintiff for failing to demonstrate professional competence in preparing the grounds of appeal in the following words, quote, in our respectful view, much more professional competence, acumen, and diligence must be expected of a lawyer of the standing and pedigree of learned counsel for the plaintiff. When such a testimonial has been handed to you, you won't find a job anywhere. But for the magnanimous exercise of its discretion to resort to the omnibus ground of appeal, the Court of Appeal would have been within its rights to strike out the whole appeal without considering the merits of the case. Therefore, any young lawyer would be well advised to learn the art of drafting pleadings that would be concise and succinct and capable of communicating the gist of the case being made on appeal. Such a skill would serve any such person well. Use of intemperate language in pleadings. Pleadings must be couched in language that could be used in the courtroom without censure. Therefore, in Obeying and Others Against Assemblies of God Church, where the Supreme Court thought counsel's language had been less than polite, the court did not hesitate to draw counsel's attention to the need to maintain decorous language on the pleadings. In the subsequent case of Mrs. Christiana Editha Jakwa Abua against Major Kilson and others, the court went further to highlight the importance of observing proper etiquette, both on pleadings and in the courtroom. In that case, the Supreme Court, per Doce JSC, took time out to address the problem of intemperate and abusive language in pleadings, submissions, and in other legal fora, because some of the things said, even in the courtroom by both counsel, were too embarrassing to repeat here. He gave a lot of advice. It's a whole page and more, so I will spare you hearing all of it. At the end, he said, a word of caution, advice, and admonition should equally go to all lawyers who take the privilege of venting their frustration in the loss of cases in the lower courts on the judges and magistrates of those courts with the use of harsh, offensive, intemperate, and inappropriate language in the formulation of their grounds of appeal and statement of cases to desist from such conduct. This court clearly frowns upon and deprecates such conduct as not only inappropriate and unprofessional, but also unlearned and ungentlemanly, and may I add, unladylike. Unfortunately, the problem still persists, so you would be well advised to remember these admonitions. Inadequate content. In Skyway Travels Limited and Ghana Commercial Bank, Sophia Akufu JSC, as she then was, lamented that, quote, it is regrettable that increasingly it is becoming apparent that many legal practitioners do not take the trouble to conduct any research or apply any logical analysis before bringing matters before this court, unquote. There are many outlets and databases now, both local and international, for research these days, and subscription to these must be seen as necessary investment by any lawyer in order to enable one keep abreast with developments in the courts. In terms of treatises, a number of Ghanaian authors have emerged who are engaged in providing good publications on Ghana law. It is thus inexcusable when pleadings lack such substance as to attract criticism from the bench and to deserve a testy remark someone is alleged to have made somewhere. My friend, if you have nothing to do, don't come and do it here. Lack of familiarity with common Latin expressions. Confusing Latin expressions such as per incuriam with the other Latin expression obiter dictum is to make a serious statement about the legal standing of a court's decision. I'm not making this up. This was in pleadings I had to work on. It is thus regrettable if counsel wishes to say that a particular principle in a decided case was not the ratio of the case, but merely comments made by the court or obiter dicta, and ends up describing the decision as one that is bad in law, per incuriam. Unsurprisingly, counsel on the other side responded with some vehemence to the suggestion that the decision given in their favor was per incuriam. Counsel took umbrage at his opposite number's statement and stated, quote, per incuriam means through lack of care, and that is an inaccurate description of the Court of Appeal's decision, unquote. And that counsel had, quote, been unable to establish how and why this decision was per incuriam, unquote. The poor guy just wanted to say obiter dictum. An even more disturbing instance is when counsel makes submissions in which the common Latin expression, and this was a case in this week, a common Latin expression prima facie or prima facie, however you pronounce it, which means on the face of it, is repeatedly rendered as primary function. One wonders what explanation there could be for such an error, for the two expressions have nothing in common. Why use a Latin expression with which one is unfamiliar? If a matter appears on the face of it to give a certain impression, which impression may be displaced by better evidence, prima facie may be used, but certainly never primary function. Poor use of language and or poor proofreading. Incompetent use of language or failure to proofread, perhaps after a non-lawyer has typed pleadings, is a constant source of concern and, dare I add, irritation. Consider the following examples, all coming out of pleadings filed by counsel since I joined the bench, so within the last year. And for obvious reasons, I can't give the source. So somebody writes, jurisdiction to retrain the respondent. Appellate courts have no jurisdiction to undertake retraining of respondents. If the person had read it well, he or she would have noticed that it is restraint that is intended, not retrain. Another one, quote, dissatisfied with the judgment of this honorable court, the applicants have appealed against same to this honorable court. This is elementary law. That's an appeal from a court, go to the same court. Another one went, regulations made under an old statute. I know many law students don't know the difference between statute and statute, so be warned. Do statutes offer shade for the making of regulations? Is the location of making regulations the vicinity of new statutes rather than old ones for you to complain about regulations made under an old statute? If somebody made law under a new statute, would it be different from law made under an old statute? Somebody also used inconsequential when he meant of no consequence. Inconsequential means of little or no importance, but it does not mean there would be no consequence if one pursued the course of action. Therefore, when counsel wishes to state that there would be no consequence and ends up saying the result is trifling or of little importance, it can create difficulties. What, in my opinion, takes the icing on the cake is for somebody to have rendered this phrase, to reside from an agreement, when he meant resile. Is anyone obliged to live close to an agreement? Had better proofreading been done, counsel would have noticed that resile had been rendered recite, and the meaning of the pleading completely altered. Please note that all the examples here did not appear only once, otherwise they would not, we all make slips. But when it appears more than twice, then I know that's your language. Please note that substantive does not mean the same as substantial. So if you are talking of substantial law, you are talking of quantity of law, not the core of law, which is substantive. Another one, with leave of this honorable court, we will argue when all counsel means is with the permission of the court. Leave has a technical meaning, and it has been defined in Brown against National Labor Commission, per Amegache JSC, that, quote, in ordinary parlance, leave implies praying to the court to grant permission to file an appeal, unquote. And clearly, this must involve a formal step of praying to the court to grant permission. Therefore, when counsel is merely being polite on the pleadings, there is no need to create difficulties by appearing to be asking for leave to do what one may do as of right. While flowery language is not prohibited in pleadings, poor proofreading can change the meaning of what one seeks to convey. I remember as a law student, I think it's the case against the King against Meade in a case on intoxication, and the judge in directing the jury went, if reason be dethroned and something, so the people promptly filed an appeal. And the appellate court said, you can speak flowery language provided the sense is right. So some people tried flowery language. I wouldn't have minded if they had proofread properly. Somebody said, somebody withstood the fire of the cross till. So I was wondering, why would anybody be subjected to a burning cross? Only to discover that counsel meant cross-examination, which had not been fully typed out. And somebody said, I relied on oath. It's a very good, I hope you notice the difference in pronunciation. When you say somebody relied on oath, it's a very good and honest thing for a witness to rely on his or her oath to affirm that the matter stated is true. However, if counsel, in fact, means to accuse a witness that he told the same lie again on oath and actually did it better at lying the second time round, then this cannot be the correct expression. This is, of course, important. This is of particular importance since counsel was, in fact, asking the court not to give any credence to the witness testimony. Very unfortunate use of language indeed. So you can't re-lie. Every lie is a fresh lie. One could go on and on about the state of pleadings, but it suffices to state that the means of communicating with the other side can mislead by inappropriate or careless use of language and inadequate proofreading. I want to look at some substance, but I can see that you are getting tired. Oh, you are not tired? don't give a teacher a blank check. So I look at jurisdiction, but I'll skip appropriate parts. Jurisdiction is defined in Edisa number 2 against Attorney General per Aqua JSC as follows, quote, jurisdiction is the power of the court to decide a matter in controversy and presupposes the existence of a duly constituted court with control over the subject matter and the parties. Jurisdiction defines the powers of courts to inquire into facts, apply the law, make decisions, and declare judgments, unquote. It must thus be noted from the outset that a court is a creature of law, as is also its authority and reach. Therefore, whenever its authority is invoked, such invocation must be backed by law and in accordance with law. This means that procedural rules of cardinal importance in whether a matter can be entertained by a court, as well as a remit of the applicable rules. Indeed, nowhere is it clearer how much sway the word of a statute has over the powers of a court than when, how, and over what subject matter a court may exercise jurisdiction. For instance, the rules for how the courts may be accessed in the superior court are prescribed in elaborate form in constitutional instruments developed by the Rules of Court Committee and passed as subsidiary legislation, CI 19 and its amendments, CI 16 and its amendments, CI 47 and its amendments. And then there's a specialized CI 74 and CI 99 for presidential election petitions developed under the authority of Article 64(3) to govern the conduct of hearings pertaining to challenges to the election of the President of the Republic. A court is granted jurisdiction by law, starting from the Constitution as the basic law. If a complaint is not cognizable under any of the jurisdictions conferred by the Constitution, then that court cannot assume jurisdiction. The Supreme Court has several separate and/or specialized jurisdictions under the Constitution. Article 130 for original jurisdiction, 131 for appellate jurisdiction, 132 for supervisory jurisdiction, 133 for its review jurisdiction, 135 for the specialized jurisdiction on the determination of the approach to be prejudicial to the security of the state or injurious to the public interest. In Article 64, in addition, Article 64 provides for the specialized and exclusive jurisdiction in respect of the determination of presidential election petitions. These various types of jurisdiction are further fleshed out in sections 2 to 8 of the Courts Act 1993, Act 459, as amended. In addition to these, Section 9 prescribes, of the Courts Act, that in a case presented to the President for the exercise of prerogative of mercy, the President may, except in the case of a sentence of death, refer the matter to the Supreme Court, which may hear it as an appeal. And Section 9A, or render an opinion for the consideration of the President if he requests assistance to resolve any related point. That's Section 9B. The Court of Appeal has, as its name suggests, jurisdiction limited to the hearing of appeals in Article 137. Article 137(2) prescribes where a case may go on appeal. Some go as of right, some with leave. I'm trying to skip some things so that we can make progress. The Court of Appeal is a final appellate court over petitions to parliamentary elections under Article 99, as there is no further appeal to the Supreme Court. The jurisdiction of the High Court is specified in Article 140. The High Court has jurisdiction in all matters, and such appellate jurisdiction and other jurisdiction as may be conferred on it by the Constitution or any other law. In addition, it has jurisdiction to enforce fundamental human rights under Article 33 of the Constitution. Jurisdiction exercised herein is appealable to the Court of Appeal and then to the Supreme Court. As noted earlier, Article 99 confers jurisdiction on the High Court to hear election petitions pertaining to whether a person has been validly elected as a member of Parliament and whether a person has been validly elected as Speaker or has vacated the position of Speaker. The distinction between the two jurisdictions attained some significance in the recent unreported case of the Republic against High Court Ho, ex parte Attorney General, Professor Margaret Kwaku, and 4 others as interested parties, otherwise referred to as the SAL case. This case involved the invocation of the review jurisdiction of the Supreme Court after it quashed an ex parte injunction granted by the whole High Court in a case seeking to stop the gazetting and swearing into Parliament of the Member of Parliament elect for the Hohoi constituency. The case was initiated by originating motion against the Electoral Commission, the Attorney General, and the Member of Parliament elect for the Hohoi constituency to enforce the human rights of persons in an area covering Santro Kofi, Akpafo, Lolo had the opportunity to vote in the parliamentary elections of 2020 by the Electoral Commission. The Attorney General moved the Supreme Court to exercise its supervisory jurisdiction, contending that the court had no jurisdiction to grant the interlocutory relief it purported to grant. The Supreme Court agreed with the Attorney General and quashed the decision, although the ex parte injunction had lapsed. The interested parties invoked the review jurisdiction of the Supreme Court under Article 133 of the Constitution, contending that errors had been made by the ordinary panel, which had resulted in a miscarriage of justice and required a second look by the Supreme Court at its own decision. The aggrieved parties argued inter alia that since the judge had jurisdiction to hear a case involving the enforcement of human rights, it had jurisdiction to grant the ex parte injunction. The case was dismissed on stated grounds. One of these was that the action at the High Court purported to be one of enforcement of human rights under Article 33 of the Constitution, but the reliefs sought pertained to the jurisdiction for election petitions. This attempt to mix and match actions and reliefs could not be countenanced because each had its own peculiarities. Whilst the action to enforce human rights could be initiated by originating motion, an election petition had to be initiated by petition, as prescribed by the Representation of Peoples Act 1992, PNDC Law 284. The two forms were not interchangeable. The point was clearly made in Republic against High Court Koforidua, ex parte Baba Jamal and others, interested parties. The Supreme Court had cause to set down the applicable regime. It's important, so indulge me to read it. There is a clear intention on the part of the framers of the Constitution and PNDC Law 284 to raise the procedure for commencement of electoral disputes to a higher pedestal. This level is that a petition, which is a separate and distinct procedure from the generally acceptable mode of initiating action in the High Court, which is stated in CI 47 to be writs of summons. In this regard, the Supreme Court must consider these provisions as a manifestation of public policy. One might then legitimately ask why the procedure for initiation of electoral disputes is separate and distinct from those generally stated in the initiation of all other action in the High Court. The answer might be that since there must be an element of early resolution of election disputes and finality in the determination of early election results, to enable whoever has emerged victorious to be known as well as the defeated candidates, a process which is swift, fast, but fair and just must be adopted for the above objectives to be achieved, unquote. Even who can be a proper party to a suit was also an issue. A human rights action is usually against the duty bearer, but not against those who have benefited from the existing rule one is complaining about. Whilst an election petition requires that not only should the Electoral Commission be sued, but also the person declared to be the winning candidate. Somebody who wants to come to UPSA Law and is denied the opportunity may sue if he thinks that his human rights have been infringed. But he cannot add you because he is not here, you got him. The nature of the action in the Sal case was further confused by the fact that whilst action was initiated by originating motion and was appealable to the Supreme Court, an election petition could not be so appealed as it terminated at the Court of Appeal. Thus, the High Court had no jurisdiction to entertain this hybrid action that appeared to be an action for enforcement of human rights in the borrowed robes of an election petition. The ex parte injunction had therefore been properly quashed, and no error had thereby been occasioned by such action of the ordinary panel. These were some of the issues thrown up in the case, which was, in fact, a human rights enforcement action dressed up in the garb of an election petition. Appeals. In appeals, as in the trial court, the rules are no less important. In Sande Manab against Asangalisa, the Supreme Court per Aqua JSC, as he then was stated, quote, now it must be appreciated that an appeal is a creature of statute, and therefore no one has an inherent right to it. Where a right of appeal is conferred as of right, or with special leave, the right is to be exercised within the four corners of the statute and the relevant procedural regulations, as the court will not have jurisdiction to grant deviations outside the parameters of the statute. Thus, one cannot use any but the statutorily prescribed means to get the court to hear one's case. The same matter came up of ignoring these rules in the Republic against Central Regional House of Chiefs Judicial Committee, ex parte ABA. It's very long, so I'm skipping it. The point has already been made. Timelines for filing appeals must be closely observed. In Togbenu and Dubaza, the 8th, an interlocutory appeal which was supposed to be lodged at the Court of Appeal within 21 days under Rule 91A of CR 19 as amended, was challenged by the other party as having been filed 1 day out of time. That is on the 22nd day, and therefore incompetent. It took an appeal to the Supreme Court to settle the issue of whether the interlocutory appeal had been filed within the prescribed 21 days or out of time by 1 day. Fortunately, the court did some counting and agreed with the respondent that the case was in fact filed on the 21st day, and so it was within time, and dismissed the appeal. I have come across others also, 2 days, 3 days, and they fight the entire time. This case illustrates the fact that unlike class assignments that are handed in after deadlines with casual excuses, pleas for clemency, and an expectation that one's excuses ought to be allowed to dislodge a set deadline, statutory timelines are not that flexible. And a failure to observe, say, can defeat the chances of success of an otherwise good case. My former students will tell you that I insist that even I died is not a good enough excuse. In like manner, you can ask some of them how they will be running after my car with their scripts. Once the deadline ends, I get into my car. I have nowhere to go, but I will leave. They will be running after me holding the script. In like manner, various forms of jurisdiction are governed by their specific rules and are ignored to the litigant's peril. A high court or even the Court of Appeal is not, and I mean not, an inferior tribunal. Therefore, even though the Supreme Court is granted jurisdiction under Article 132 of the Constitution to supervise its proceedings, it does so sparingly and only when the decision goes to the root of its jurisdiction. Otherwise, a litigant's remedy lies in an appeal, not in certiorari. These cases keep coming, and I hear the lawyers say it's faster. So they come for certiorari, and we regularly shoot the process down because a high court is not an inferior tribunal. So if it hasn't stepped out of its bounds, it has only made a mistake within its bounds, your remedy is an appeal. Similarly, the review jurisdiction of the Supreme Court is not a pseudonym or a polite name for appeal, nor is it a backhanded means of granting appellate jurisdiction. Rule 5.4 of CI 16 as amended specifies the circumstances of its exercise, and the Supreme Court has been particular in guarding the bounds of that jurisdiction. This is important, but we are out of time. It will give you something interesting to read when the paper is published. Dean Abochi, you intend to publish, don't you? Okay. So it will give you something to read, those of you who are allergic to reading. But there's a shorter version in Opoku number 3 against Access Company Limited number 3, when Akamba JSC said, quote, the review jurisdiction avails an applicant where there are exceptional circumstances which, if unaddressed, would perpetrate a miscarriage of justice. It is not another avenue for re-arguing or repeating or refashioning previous arguments as in an appeal. Nor is it an opportunity for a party to revisit and come out with more ingenious arguments, which he believes will find favor with the tribunal. Simply put, a review is not an opportunity to have another bite of the cherry, unquote. The nature of the review jurisdiction is thus a very special jurisdiction and should remain so. I look quickly at capacity. The rules also prescribe who may bring an action and who may defend an action. The law is not for those who have nothing better to do for entertainment. So one must have some standing or cognizable interest to vindicate one's rights. The rules specify these in detail to avoid the situation of having a phantom plaintiff or a phantom defendant. We certainly don't want anybody coming to court for entertainment. Consequently, the issue of capacity can be raised at any time in the course of a suit, and even on appeal for the first time. I cite Dugbato Sapo against Dugbato Sapo, in which Mensa Bonsu JSC held that capacity to bring and maintain the action remains a cardinal hurdle that must be jumped if either party is to remain in the case. It is a long quotation, so I skip some and I say, accordingly, one's ability to appear in court to make a claim hinges on whether one is recognized in law as having sufficient interest in any matter to seek a hearing on any particular case. This sufficient interest must remain throughout the life of the case, or one's legal ability to stay connected with the case, making its way through the courts, would be lost. The courts are not for officious bystanders or meddlesome interlopers. And the issue of capacity can be raised at any time. Having skipped these, I get, let me read the last case so that I can go to the conclusion. In Nipo the third and 2 others against Agri Cattle and 4 others, the Supreme Court held as follows. The law is trite that capacity is a fundamental and crucial matter that affects the very root of a suit. And for that matter, it can be raised at any time, even after judgment on appeal. The issue is so fundamental that when it is raised at an early stage of the proceedings, a court, mindful in doing justice, ought to determine that issue before further proceedings are taken to determine the merits of the case. Thus, a plaintiff whose capacity is challenged needs to adduce credible evidence at the earliest opportunity to satisfy the court that it had the requisite capacity to invoke the jurisdiction of the court. If this is not done, the entire proceedings founded on an action by the plaintiff without capacity would be nullified, should the fact of non-capacity be proved, unquote. Now to the part you have all been longing for. I'm told that the most popular phrase in the English language is "in conclusion." In this 1 year, when I have switched sides from one constantly critiquing judgments to one applying them to establish legitimacy, I have undergone mental and psychological reorientation. I have come to acknowledge that contrary to what is believed in academia, procedural rules are not inferior to substantive rules in any measure. Indeed, procedural rules are the vehicles in which substantive principles ride in order to do justice. I don't know whether it's Okada or Uber, but. And that a failure to appreciate the role of procedure and procedural rules would be the undoing of any promising career in the law. I have also come to appreciate the value of my own strictures to my students to read and improve their vocabulary, as I have watched a case with otherwise good prospects get damaged or destroyed by poor lawyering. I have had to constantly remind myself, as I do to students at tutorials, not to form an emotional bond with either party, for therein lies the danger of perversion of justice. As a law teacher, I have also felt vindicated by the effects of a lack of diligence on the part of legal practitioners on the case of their clients. Unlike the teachers of the law in the Bible, you know, we are the only ones mentioned in the Bible apart from farmers. Unlike the teachers of the law in the Bible, I have not put on the heads of my students burdens that I have not been willing to carry myself, nor have I taken away the key of learning from them. This lecture is proof that by sharing experiences and learning lessons from my year's stint on the bench, I am availing to others the key of knowledge that I have been privileged to acquire, so that we can together improve ourselves and get better at what we do. I cannot conclude without emphasizing that to have a successful career on the bench or at the bar, one must, in or out of law school, nurture by diligence the following qualities. Again, I'm quoting from a lecture I gave at the Faculty of Law, University of Cape Coast. A reputation for checking the authenticity of information and sources before relying on them. Never be heard to say, the man was a very decent and respectable man, so you believed. Never relying upon other people after making assumptions about their integrity. And insistence on patient proofreading of any document leaving one's desk to some other destination. These are sure to be invaluable in the practice of any aspect of the legal profession. In a country where diligence in upholding rules is represented as wickedness and dereliction of duty is interpreted as kindness, one cannot emphasize enough how important this quality of diligence is in a lawyer, unquote. One cannot go around the wording of statute or other procedural laws by sophistry or fine arguments, but one can do oneself a lot of good by crafting pleadings that comply with the rules and by conveying one's case in appropriate language. It's not only abusive language that is annoying, supercilious or condescending language is equally annoying. On joining the bench, I was suddenly conscious of how much more I had to know if the succeeding years were going to be easier than the first year. Consequently, I have returned to my old habits of staking out the library. Thankfully, this time I can afford it, so it's in my own house. And reading as if my life depended upon it. Indeed, I have applied myself to my studies as if I were only just beginning life as a first-year law student. I have come to appreciate that in this endeavor of learning and applying the law, it would be well to keep in mind that one can never know too much. The view from the ringside is pretty, and so I exhort you to continue to strive to attain more knowledge. For in the wise words of the English poet Alexander Pope, and I'm quoting him, "A little learning is a dangerous thing. Drink deep or taste not the Pyrean spring. There shallow draughts intoxicate the brain, and drinking largely sobers us again." He goes on, "While from the bounded level of our mind, short views we take, nor see the lengths behind, but more advanced, behold with strange surprise, new distant scenes of endless science arise," unquote. I encourage you to strive up the hill of knowledge in anticipation of the yet to be glimpsed vistas, which would hopefully leave you in even more awe of the law, to whose study you have made a commitment, which I hope would be lifelong. I thank you for your attention. I was six.
This is very Billy. I think we can do better for Professor. Please be seated. Thank you very much, Professor. We've had enough and also the experience of listening to about an hour and a half of brilliance and excellence. I know many of us may have questions or a few comments to pass on the lecture. So we'll invite Professor Kwao to lead us or to lead this session of questions and answers.
Thank you. Prof, may I exercise some rights?
Yes.
I reserve the right to answer a question or not to answer a question.
Exactly.
Or to postpone it to next year.
Yes. Before I take my seat, there is one thing that I must do, which I didn't do earlier. As Her Ladyship was sitting there was a very elegant gentleman who walked and took, two elegant gentlemen walked and took a seat, one beside her and one behind her. The first gentleman she introduced as a master of Okwafuho a number of years back. I used to be a student of Okwafuho. So I should, in all, pay some homage to you, sir. And last but not the least, Your Ladyship, your husband took a seat beside you. I have never met him before. This is the first time.
Okay.
But I think
He's the one and only KMB.
he's the one and only KMB. So, sir, I should also say hello to you.
Thank you. We have been illumined, we have been treated to a very important topic. I find myself slightly confused for one important reason. I am an academic, and as an academic, I have always considered that what we do, the discussions we have as students are important, and they prepare them adequately for careers after the School of Law, after law school. A number of years back, one of my former students walked up to me and said, Prof, he didn't understand why we were studying tort, contract, etc. He was a businessman, and he said, anytime he follows his lawyer to court, they don't do book law. So why all this book law? So today when Her Ladyship was giving her lecture, I said, this is exactly what the gentleman says. So first, thank you, Your Ladyship, for the very illuminating lecture. But then the question that I have is, there seems to be a gap between what we teach at law schools and what students eventually find that they have to do. So how do we bridge the gap, or should we even attempt to bridge this gap?
Thank you very much. The nature of the enterprise of law is such that it's about everything. No, I'm fine, thank you. And you can't study everything at one go. So we have to divide it up into courses. That has the effect of giving a somewhat fractured image of law. And particularly in these course credit times, people think once they've finished a course, they should get rid of their material. I've always told my students, law doesn't work that way. When you finish the semester, gather your notes and your case briefs and pack them away nicely, because you are going to need them. So letting the students understand that the fact that they are learning this aspect of law does not mean that's all there is to it. It is related to something else, and it is related to another thing else, and it is related to a third thing. So you can't break up the law such that whatever you study at one stage has nothing to do with what you study later. I've always told my students, for example, learn your criminal law well. Nobody's going to teach you criminal law again. The next time you come up against it, it will be criminal procedure, which criminal procedure is built upon the substantive criminal law. So if you cut corners and give yourself tips, and you are lucky and your tips drop and you do well, don't think you know the subject, because you will sweat in law school. And everybody presumes that you know the substance, because your transcript will say so. My own late teacher, Mr. B.J. Darucha of blessed memory, he taught us civil procedure. And he would come to class and say, your knowledge of the substantive law is irrebutably presumed. We laughed then, but now we know that's the truth. Everybody presumes you know the substantive law. What you don't know is the procedure, which they then proceed to teach you. But you can't get the procedure right if you don't understand the substantive law. And the result is that you struggle in the professional course. So my long answer to your short question is that it is the nature of the enterprise. The students should just know that this is only one aspect of it that we teach in that way so that you can understand it and appreciate it. But that's not the only thing. And that's why you should also encourage your students to read the cases. They don't read. In fact, some are so allergic to reading that when you start saying read, they are already there. Maybe you want to talk of Real Madrid. And those who try to read, take a shortcut and read head notes. Head notes are not written by the judges. Head notes are summaries that the court or the law reporters do of the cases. So if you are reading only head notes, in fact, you are reading law as secondhand. And again, my former students will remember that I say that law cannot be done as secondhand. Law cannot be done by rumor. No. You don't do law by rumor. You don't do law by secondhand. Read the cases yourself. You see, the more you read the cases, the more familiar you get with judicial craft. Nobody is going to sit you down and teach you how to put things together. But because you've read many cases, it comes to you as second nature. So the students must know that part of what they need to know, you have taught them. The other part they will know by reading the cases, because no case is about only one principle. Usually there are lots of other principles. I will confess that I myself would read a case and not read the procedural part because I was in a hurry to take my substantive principle. Of course, now I am wiser. So the more cases they read for themselves, the more some of these things will come to them naturally, as if they've always known them, but it may come from the skill of reading cases regularly.
Thank you. So students, you heard, we've always been telling you to read cases. If you do not take it from Dean Abochi or Madam Gertrude or any of us, I hope at least that you would heed the words of a leadership and read your cases. I have one more question and then we'll open the floor to others. Do you have any recommendations for how we teach? I know you've mentioned earlier that we should let students understand that what we are teaching them is part of what they should know. Do you have any recommendations with respect to how we actually go about teaching them with the benefit of your experience, many years as an academic, and now being on the bench? For instance, do we teach drafting? Should we teach them how to draft claims, or should we just leave it for the professional program?
Let me say that I'm somewhat old-fashioned. There are no shortcuts. Somebody who is learning drafting, for example, or learning whatever subject, would be better served having a good vocabulary than some set ways of drafting things, because you don't have any control over any of the cases that come to you. So you can't say, as for me, this is the only case. Maybe when you are a very senior lawyer, you will be able to say, I will take this case and not that case. But when you are a very junior lawyer, you won't have that. But if you have a good command over language, you can do anything. But many of our students, if you are one, you are the one I'm talking to. Many have got here without reading anything but textbooks. I'm afraid the language of textbooks will not take you far. Sometimes you can tell from an answer somebody is given that the person knows the answer, but doesn't have the language. If the person had been giving an answer orally, then they would have supplemented with body gestures. But in writing, they don't have the words with which to express the idea they need expressed. Again, for over many years, I've told my students, the farmer who is going to the farm with a cutlass is not shy about sharpening the cutlass so that it can work better on the farm. Why should a lawyer be shy of improving vocabulary? Your cutlass is the language. So read anything, and I beg you, not motivational books written in bad English. But read things that give you a facility of language, because when you are in trouble, you need the language to get you out of it. If you don't have it, then you go and hoping the other person will supply the word. The other person may also not know the word, with the result that somebody who was talking about reincarnation had some other resurrection version. And when he was corrected, he said, hey, that was what I meant. Reincarnation was what I meant. So please, read anything, any good novel, any of the classics, anything that would be interesting to you, because you do need the language. And don't forget, if you are a farmer or a butcher, you need a sharp knife. And nobody is going to listen to you if you make a mess of things and you say your knife was not sharp enough.
Thank you. So we'll now take two questions. Excuse me. Oh, yes. Two questions. We'll take them together and her leadership will address both. Anyone? Yes. What is the question, sir? Tell us your name and then you ask.
We can't hear. The
can't.
microphone is not on.
Good evening. My name is John, former student of UPSA.
Your name is God?
John IAJ.
John.
Former student of UPSA. I have a question in respect of the role of procedures. We know that the aim of the court is to enforce justice. And where does the court draw the line between enforcing justice and striking cases out based on technicality?
Okay. Second and last question. Okay, so that probably is the last question, Your Ladyship.
The Supreme Court has said that it will not let technical rules defeat substantive justice. But there's a limit to which you can do this. Don't forget that justice always has two sides. I'm talking of the parties. There are always two sides in court. So anytime you let one get away with something, you have done it to the prejudice of the other person. At least you accept that, do you? And the other person is also very conscious. Remember this Togbenu case that I cited. The man was out of time by 1 day. 1 day. And even depending upon how you calculate it, he wasn't out of time, as the Supreme Court found. But that would have defeated it, because the law says, and that was one of the surprises I had on the bench, the vehemence with which counsel will argue that the thing is 3 days late, and the rule says, and they will quote long English to you. And true, the rule says, so when the rule says that, and everybody is working with that, should you be allowed to make your own rules? That's not justice. If every time people come, they can walk in at any time and come and make a case. Look at the rules of the statute of limitations, for example. It fixes time limits for cases that may be brought under different heads. If somebody has suffered such a severe injury, why should there be a limit? But why shouldn't there be? Why should somebody who causes injury to another for the rest of his life be doing penance? Every time he hears a door open, he jumps. Maybe the people have come and make a claim. By a certain time, he should be able to relax and say, they didn't bring the action in this time, so I'm okay. You appreciate that. So, justice demands that the rules that have been declared in advance be respected by both sides. Sometimes the court may strike down the pleadings, and as you saw in some of the cases I cited, the court said, you're lucky, we won't strike it down, because we know it's a mistake the lawyer made, and we don't want that mistake to cost the client. So if the law allows discretion, the court will always exercise the discretion in the manner that they think fit. But if it doesn't, it doesn't. Sorry.
There was one. Is there one? The last question. Okay.
Thank you very much. Respectfully, my name is Victoria Akosia Uenchi, and I want to find out from you what advice you will give to young female law students who would want to be like you in future. Thank you.
I didn't know that there was a special way of learning law by females. I was always telling my students at tutorials when somebody say, and the lady, I said, which lady? Said, this person would point at a classmate. I said, there are no ladies here. They are only students. That's my answer. There is no different way of learning law by females as opposed to males. Some things require better organization of oneself. Some aspects of the career are troublesome. But in terms of learning law, why you want 50% when a male will get 45? I'll never do that. A woman does not have half a brain for you to indulge the person's half brain. I'm always blaming fathers who tell their daughters, oh, as for you, you will get married. So they don't demand high standards from their daughters. Is it every woman who gets married? What if you marry a fool? So if the mark the child has brought home is not good for a boy, it's not good for a girl. That's how you encourage mediocrity. Letting females think they don't need to work hard, they don't need to think hard, they don't need to strive. In this day, which man can afford to look after his wife in the way that our great-great-great-grandparents who only bought one cloth a year did? By the way, my daughter is here, Miss Mensa Bonsu. She's a lecturer at the School of Law, University of Ghana. Please take a bow. Let them know.
Please rise. Please rise.
Let them know that I don't have any demands that are different from anybody. A woman doesn't have half a brain. You have a full brain. Use it. Sometimes you are even blessed with common sense. Add it.
Thank you, Your Ladyship, and I will hand over the microphone to our MC.
I thought I had been discharged.
Oh, no, I thought you will do the discharging. Okay. Yes.
Her Ladyship, the judge, I have the singular honor of discharging you.
He's retired now. He claims he's retired.
So Justice Kokojan, retired Justice. Thank you very much, Your Ladyship. Thank you very much, Professor Kwao.
Oh, wait.
Please give it up for Her Ladyship. We treated to a display.
In coronavirus days, I have to cover my credit card.
Her favorite parts are being covered. Thank you very much, Her Ladyship. We'll take just a 2-minute final comment from the Dean. Gertrude.
Good. Covered it. Stand there. Don't go away. My lords, distinguished colleagues, guests, students, ladies and gentlemen, Professor Justice Mensa Bonsu has not disappointed. True to expectation, she has delivered. I was skimming through, and I'm probably breaching the rule against reading cases carefully, but I was skimming through a judgment you've delivered in the case of Amasewa versus Gariba Hashimu. And the introductory part of your judgment reminded me of your famous assignment on village chief. Professor Mensa Bonsu was, with the greatest respect and hopefully avoiding judicial contempt, was notorious, positively notorious, for giving a particular assignment that students hardly did well. Single-digit performances were standard. And you were informed as soon as you came to first year that you should expect that assignment, and somehow it came very quickly, predictably. And she would come to class to remind you of what she used to call then the baptism of fire, where law students were not law students until you go past the first year, because the possibility is that you'll be dropped out to go and read some other course. As she advised you on reading, I just thought to myself, those were the days of trepidation. Those were the days of fear, probably guided by innocence, because we're actually innocent as students. Today's world is too, maybe the knowledge of today seems to have demystified so many things that with the loss of mystery has also come some level of indiscipline. And therefore, students are very hard to advise these days. So therefore, it's hard to tell students today to read, because they actually look at you thinking, you made a mistake to read. There's a better way. And that better way will lead you to glory land without necessarily having to undertake the path of difficulty. So it was heartwarming to hear you advise my students, our students, on the need to pursue the right path. because there's a way that seemeth right to man, but in the notes. So once again, I would like to, on behalf of my faculty members, on behalf of my students, on behalf of all those gathered here today, very deeply and from the bottom of my heart, thank Professor Mensa Bonsu for her master, for her mastery and the competent manner in which she's handled the topic of a ringside view of the significance of procedural rules and pleadings in the practice of law. I must say that I had a few doubts, as I indicated at the beginning before you spoke. And part of my doubts were inspired by the fact that other jurisdictions appear to be going down low on procedures, in India being a notable one, whereby the process they call the epistolary rule, you can actually appear in the Supreme Court with a simple letter. You don't need to really go through procedures. But Prof. Justice has indicated clearly that the procedure disciplines all of us to follow a certain path so that there's predictability, so that we all have a certain clarity. And as she went through correcting English, I'm not surprised at all, because this has been the case since the days of us being in first year law and praying to God that having told everybody we are law students, we don't end up not going past the first year and now not knowing what to tell people. As many of you, I'm sure, have already started, behaving in that manner, we're actually called lawyers by our colleagues on campus, and we responded with a high five. And the embarrassment of not having passed the exam and then having taken all the funds, we thank God that we made it, and we do pray that you will make it. But guess what? The amen must be accompanied by hidden advice, which you have had a lot of. The lecture will be published once it has gone through the process, and I'm confident that's going to be procedure, just a formality. It will be published in the UPSA Africa International and Comparative Law Journal. For those of you who are wondering, what is that? We have a copy here. And Professor Mensa Bonsu is going to get one of the very first copies. So I read to you my small message, which we have written, the complimentary message, that says that this is specially presented to you on the occasion of your lecture at the UPSA Law School with the warmest compliments of the Dean, signed, dated 27th May 2021, and with the greatest respect and humility, I invite Prof. Justice to step forward.
Hey, you can still speak. Use the mic.
I'm done.
All right.
Yes.
Okay.
Thank you very much, Prof. So the vote of thanks, I'm sure, will be given, but let me thank everyone at this stage, and once again, especially reiterate my special thanks to Professor Justice Henrietta Mensa Bonsu, to Mr. Mensa Bonsu. The many years of marriage that was mentioned was quite humbling. We appreciate that. And to my Lord Justice John, who head of the program only at 3 o'clock. And because 3:30, and because of his love for Professor Mensa Bonsu, and certainly your love for UPSA as well. Yes. And the reason I'm here, I'm honored. So, I am most humbled, and thank you all very much. Everyone who's here for the love of Prof. Everyone, Mr. Clement Akapame, my former colleague at GIMPA, another Mensa Bonsu who's at Legon, a colleague at Legon. So I hear when I say we're better than Legon, but that's fine. Now you can keep it. You can keep it quietly. Don't tell Dean Raymond Tuguba, who's a good friend of mine. But it's all right. We can take it from there. I wish to thank my colleagues who are very well represented here. the faculty members, the lecturers, thank you very much. I know that many of you are going through very difficult times of marking and teaching at the same time and adjusting to the corona difficulties. I really appreciate the fact that you're all here. At UPSA Law, we believe in the academic enterprise as being one that transcends a teacher standing in front of students and teaching. As Prof said in her lecture, the real essence of this exercise is that you should hear the other view. And so lecturers speak to you, but the other distinguished views in town, they also visit us routinely, and we're delighted that Prof responded positively once she was called upon. If I haven't mentioned your name because I can't identify you and you're distinguished, please, all protocols are observed. Thank you.
Thank you very much, Dean. So as not to neutralize what the Dean has said, we'll invite Mrs. Asante to wrap up the vote of thanks.
Dean has done everything for me, but I'll still do it. To God be the glory, great things he's done. It's always a pleasure to be under your feet. Yes, Mom. But lady, we are grateful for coming out this evening to give us the best of you, as always. Thank you very much. Thank you, Kweku, for giving her the best of support a husband can. We're very grateful. Mommy, thank you for coming with Mommy. Good to see you. My Lord, thank you very much for being with us. Prof, thank you. Thank you for your presence tonight. Prof Dean, thank you very much for your input. It couldn't have been without you. And our heads, Prof Kwao and Dr. Franca, I saw you around. Thank you very much. Thank you for our senior members from UPSA Law School. And my former TA, he's here. Thank you very much, Uncle Clement. Thank you, our cherished students, for coming out. Wow. Dean, should we cancel tonight's lectures? No. Thank you very much, guys, for coming out. Thank you for the staff of UPSA and our media partners. We are very grateful. Thank you so much for following us all the time. If tomorrow you hear the 6 o'clock news from Peace FM, it is the UPSA Law School saying thank you very much for tonight.
Thank you very much, Mr. Asante. And a very big thank you to everybody for staying till the end of the program. Since we started with God, I think it's right we end with God. So we invite James Anaya, who is here with us, to give a closing prayer. When it's done, we kindly request that we all remain seated, then we take the photography. When it's done, let's kindly remain seated, then we take the photographs.
Shall we pray? Father, we are grateful unto you for your favor, your mercies upon us, that you have taken us through this program successfully. We pray, O Lord, that you shall take everybody back to their home and their destinations. In the end, we'll give you glory and honor. In Jesus Christ's name we pray. Amen.
Amen. Thank you very much, Mr. Anaya. My name is Kweku Atakrajimo, and I've been your moderator for today. We'll end with photographs, and Professor Mensa, if you can kindly join me here, would all join you in taking photographs with all COVID measures being strictly adhered to. We'll take one with the Dean, Professor Mensa Bonsu, and the Dean, the first round of photographs. The heads of the department should kindly get ready. You'll join the Dean and Professor Mensa Bonsu after they are done with this one.